Well, it's a great pleasure to be here again. I'm Benjamin Berger, and I moved to Osgoode and York University only about 3 years ago. I taught at the University of Victoria. I grew up in Alberta and taught at the University of Victoria for about 7 years before I came here. And I've been looking forward very much to building opportunities to engage more with the broad York community, with alumni, and to engage with this part of the city. And so I'm grateful for you having me here and giving me a little bit of time to chat with you about some of my research, some of the themes and questions that drive the work that I'm doing. As James said, I teach criminal law, I teach evidence, I teach constitutional law at Osgoode. But the principal part of my research and teaching in recent years has been about questions of law and religion. When I started working on these topics, about 15 years ago or so, they were not nearly as omnipresent as they are right now. Today, right, we see these issues internationally every day, right? We see the issues arise in Canada with increasing urgency, with increasing interest, with increasing complication. And so in general, we wonder together frequently, should religious symbols be permitted in public institutions? And specifically, we have cases that end up talking about things like, should a child be able to wear a kirpan, a ceremonial dagger, at school? Again, broadly, generally, we think, well, how are we going to balance things like equality and religious freedom? And then specifically, we're met with questions like right now, should law societies across the country accredit a program, Trinity Western University's program, that is a law program training public lawyers, but that expressly discriminates against sexual minorities? What do you do about religious difference and same-sex marriage, right? These are questions that have been on our minds. And again, generally, we ask questions in Ontario like, what do you do about the use of religious law in private arbitration? Should there be accommodation? We saw a recent case for face coverings, religiously motivated, in courtrooms. So these questions buzz around us. They circulate with a lot of energy, and there's a great deal that, in my view, slides through those conversations without getting a good hard look. For example, we don't actually know publicly that much about the relationship between law and religion in Canadian history. We don't talk a lot about that. We don't know a lot about that. Very importantly for this talk, we imagine that we know what secularism is. And we lean on that in our conversations all the time. But I don't think we're careful about understanding what that concept, which is going to be a focus of my talk the next 45 minutes or so before we have a chance to chat a little bit together, that concept of secularism, what does it actually designate, right? What does it capture? We use it all the time, but do we know what we mean by it? And so one of my take-home points today is going to be to make some observations about this question of how we might think more sophisticatedly, more thoughtfully about the notion of the secular, right? And how we see that, in fact, it turns out that we need to look locally, we need to look particularly, we need to look at the histories of the place we're talking about to get the traction that I think we're after. And so today I'm going to take the Quebec Charter issue that arose this past year, and I think now, temporarily, I'd say, is on the back burner, but raised some really interesting issues about secularism and the relationship between law and religion in Canada. Right? It raised some questions about what people were meaning when they were invoking secularism within Quebec, internationally, and within Canada. What does secularism mean? Right? What has it meant? What did it mean? And importantly, what was it doing as a concept in this Quebec Charter debate, which I'm going to talk you through and remind you of the details of. So I'd like to give you a bit of comparison to some other jurisdictions. I'd like to push us all to think a little more carefully about patterns that we're seeing, about the limits of some of the concepts that we lean on very readily, very easily. And I don't want to just give you a sort of journalistic take, right? One of the things I like about the York Circle events is it's about exposing you to the sorts of things we're reading and we're thinking about and the kind of complicated elements. And so this is the sort of thing that I would present in my seminar on law and religion at Osgoode, and I hope that it'll be of interest to you as well. So I'm going to come at this a little bit elliptically. I'm going to come from over here and hopefully let us arrive at something central. And I'll speak through a few of these concepts. Okay, so let me give you something from a really interesting piece of scholarship that gets us a little closer to the issues that I want to bring us to today. In 2008, James Whitman, a professor at Yale Law School, published a really interesting article in a journal called Historical Reflections. And the article was entitled, "Separating Church and State, the Atlantic Divide." And I'm kind of fond of this article for a bunch of reasons that I'll tell you about, reasons related to the kind of inquiry that I want to do with you today. And I'm also going to note right now, there's a little point of irritation that I have about this article that really isn't about the argument, but is sort of productive as a point of irritation for a few of the points I want to make today. But let me first talk about the argument and why I thought it was so interesting. Whitman asked a really nice question, which was essentially about the usefulness or the intelligibility of the terms that we use to classify various happenings we see taking place in the world of law and religion. And in particular, he was interested in pushing us to think about how they can actually distract us, these concepts, these organizing ideas, distract us from other points of inquiry, lead us astray. This piece shows how these broader organizing concepts can kind of obscure, big concepts, right? Freedom of religion, secularism, right? Can distract us from the particularities of the history, of the local, of the moment, understanding actually the world that the concepts are trying to organize, trying to apply. And the concept that he was interested in, you know where I'm headed, the concept I'm interested in here is the concept of the secular and how it can cover up what's really going on in some way. He was interested in a different concept, if we can call it a concept, the idea of the separation of church and state. And his question was a fabulous one, a neat one. My summary, his paper asked in essence, how could it be that both Europeans and Americans claim that they enjoy in their systems a separation of church and state, that they both claim that the other does not have a separation of church and state, and they're both right? How is that possible? You see, he noted that Americans look to the substantial schemes of state funding that support and religion and exist in Northern and Western Europe for religion. And here we're talking funding for schools, financial and structural support for churches and religious organizations, right? Even funding and paying for clergy for religious organizations and public institutions. And Americans, he says, look at this and say this strikingly fails on any good account of the separation of church and state. You don't have it. Europeans, by contrast, look to the United States and the saturation of political and legal language and discourse with religion. They see that religion is highly salient in public policy, right? In Congress, in the way that leaders speak. And they say, look at that. Look at that saturation of public and legal life with language about religion. This is an egregious failure of a good concept of the separation of church and state. Whitman's really nice contribution is to say, and it's a kind of modest point, but it's got this clarity, is to point out that we could actually be talking about at least two kinds of separation of church and state. We could imagine, if we look at the local particularities, at least two sorts of ways of thinking relevantly about separationism. Both of these ways have their virtues. Both of these ways have their pathologies. But we actually miss that detail if we just talk at the broad level of separation, right? Church and state, separation of church and state. We miss this. And so he says, on the one hand, you could be interested in institutional separation, keeping the institutions of government separate from the institutions of religion. By contrast, you could be interested in the separation of religion from politics and law. In the US, separationism is all about keeping the institutions apart, but the language flows quite freely. In Europe, they're not worried about institutional mixing, but they want politics and law to have space from language and debate about religion. And so both continental Europe and the US have intelligible claims about separationism, but both are actually kind of shocking to the other. Now, if you get under that and you say, okay, well, what do you understand as these particularities that are happening under the level of concept? Whitman says, you have to look at the history of how these things shaped up. You have to look, most interestingly, at one explanation that we often would lean on being clearly inadequate. A lot of people look at this and they say, well, the reason for these separations is that in Europe, Northern, Western Europe, is essentially Catholic. And so institutional mixing is understandable. But the Protestant nature of the American project, right, means that the institutions are suspect, but individual conscience matters. And he says this is plainly inadequate, right? Catholicism was a big part of life in the US in certain areas. And of course, Protestantism, right, it was born in Germany, right, had this life in Europe. That can't be the point. And so he says instead, if you push away the kind of broad, unhelpful, big concept of separationism, and you look instead at historical sociology, you see that in Europe, over centuries of having a state, right, the state absorbed many of the functions of the church over time. Welfare functions, public functions. Right? So institutional kind of touching was not a big concern. In the United States, however, that never happened. And so it left this really politically active, highly salient layer of religious life that had a lot to say about what government would look like and what government should do. Now, that's not what I'm trying to really leave you with. What I'm trying to show you is the ways in which, if you stay at the level of the concept of separationism, you miss all of the interesting stuff, right? So why begin this account with Whitman's paper, which has a little to do with my talk, right? But is a little bit more of a method. It's interesting in and of itself, but I want to use it to point to a few of the things that I want to talk about today in my talk. First of all, the first thing I think it kind of gestures us towards is that, you'll recall I said there's this little point of irritation in the paper. And I would touch on it, something separate from that argument. And the point of irritation for me is the title, right? It's the idea that the Atlantic divide is a plausible way about talking about a comparative difference between the US and Northern and Western continental Europe. On the European side, to call that the Atlantic divide has to cut out Britain, right? It has to do some really fancy footwork around the various kinds of ways that separation looks in different countries in Europe on the continent. So it has to get rid of a lot to call that an Atlantic divide. More pertinent to us for today, right? Whitman keeps calling North American what is insistently US, which is a habit. And the case I want to explore today points to a really rich range of North American happenings in the world of law and religion that would thicken up our resources for thinking about the ways that religion, law, and politics can be assembled. Ways that this continent has produced varieties of different relationships and configurations. So that's one thing that he kind of interestingly, unwittingly points himself to. The example I'm going to be giving you today is, as you know, from Quebec. And I want to pause here to note what's often forgotten on all three sides of the North American borders. And that's the idea that there's actually a conjoined history of constitutionalism in the United States, Canada, and Mexico, right? All of them, Spain, France, and England, were involved in. Right? They all were part of a project of a certain kind of constitutional life, colonial life in North America. And the people that see this most clearly, that it's in a sense one conjoined project, are of course the indigenous peoples. Right? They see very clearly that what matters most is the commonality of the experience, not so much where the line got drawn because of the salmon wars. Right? And turning to the case at hand, it's often forgotten too easily in both Canada and in the US that the story of Quebec is actually, in a way, a story about the American Revolution and the US Constitution. Canada being composed, English Canada, remember, being composed essentially of American loyalists, a very small English-speaking population, essentially American loyalists. And the revolution in the US and the project of American manifest destiny, creating the alliances that made possible Canada and a political life for Quebec. Right? And so in one sense, what I'm saying is it's really important to understand that we're actually part of a variety of constitutional experiences. And as much as we like to kind of split them naturally on borders, there's more movement than if you lean on here another big concept, the concept of the nation. Right? It's much more interesting. So I want to offer basically today something that thickens up our resources for thinking about religion and state in North America. But second, the story that I want to offer from Quebec is in service of another point, something that's sort of sympathetic to Whitman's argument. One of the lessons of the article is something I think is very true, that in order to travel large explanatory distances, concepts have to get sort of light and thin. Right? If they're going to travel large distances, they have to be light and thin in some way. But as they start becoming light and thin, they lose depth in explanatory value. They travel far, but they tell us less. Separationism does that. You get very light and thin, so it can talk about many things. It turns out, though, that as it becomes thin, it tells us less. My point for the talk today is really an appeal to the concept of the secular and how that problem might afflict it as well. The lesson of the example I'm going to talk us through, and hopefully our conversations, is a kind of skepticism I'd like to invite you to entertain about the nature of the secular or what secularism demands. We often talk about what secularism demands, and I'm inviting you into a kind of skeptical posture when you hear those claims. So before I get to the case itself, let me point to one more theme I want to draw out, one that binds these first 2 points. I'm going to be asking you to look at secularism and the broad, big claim as linked to political sovereignty. That religion and secularism is linked to sovereignties for people, politics. And when I ask you to do that, I think whenever we're asked to do something like that, think about the relationship between religion and political sovereignty, right? Our attention quickly goes to more exotic and distant places, right? We think about Egypt, or we think about Pakistan, right? Or we think maybe about France and its relationship to Northern Africa. But the story that I'm going to tell you is saying, no, religion, politics, and sovereignty is also a very local story, right? One about Canada. And so let's turn to that story, if you'll allow me. Right? The case I want to look at is this Charter of Quebec Values, and I'll give you a little bit of a refresher on what it involved and what it looks like, though you saw lots about it, no doubt. In the fall of 2013, a minority government formed by the Parti Québécois, the Sovereigntist Party in Quebec, made news in Canada, made news around the world, by proposing to institute what it called the Charter of Quebec Values. And that's going to be important to me in the talk, that they called it the Charter of Quebec Values. Many called it the Charter of Secularism, right? And you'll see why. That label, the Charter of Secularism, came as a product of Premier Pauline Marois' claim that the legislation she was going to support, that I'll explain in a moment, was designed to just codify and entrench principles of state neutrality in matters of religion, and specifically Quebec's commitment to secularism. She said this is about secularism. And to give you a sense of the purpose and the thrust of this legislation, this was Section 1 of the bill. In the pursuit of its mission, a public body must remain neutral in religious matters and reflect the secular nature of the state, while making allowance, if applicable, for the emblematic and toponymic elements of Quebec's cultural heritage that testify to its history. Right? It's about the secular nature of the state. What are the emblematic elements that they reflect? A concession for emblematic elements. This is in the National Assembly, and you saw many, right? There's a crucifix, right? You see one flag, not two, right? Of course, you see one flag. And you see a crucifix above. And so you might also, and I could show you a slide, of Mont-Royal, right? And the cross that sits up there, that was put up there and looks over the city, right? In the 19th century and had important symbolic elements for the culture. Toponymic, what's that? Places, names of places. So they're trying to say they're toponymic, right? We're not going to get rid of Saint-Hubert Street or Saint-Laurent Street. That's what they mean, okay? Now let me just give you some context here. The proposal, of course, set up concerns about the accommodation of religious practices in the province of Quebec, and that was itself riding on concerns and issues over the last 10 years or so across Canada. It was across Canada, but you appreciate, of course, that issues of culture and issues of difference have a certain salience in Quebec. And so these concerns about accommodation of religious difference were actually found all over Canada, but they had this sort of purchase in Quebec. Certain court decisions implementing toleration or acceptance of religious practices, a kind of notion of multiculturalism that was at least rhetorically very Canadian, these produced worries in Quebec, enough worries that it produced this Bouchard-Taylor report, right, an inquiry into practices of religious accommodation in Quebec. And Bouchard-Taylor, Taylor is Charles Taylor, an important Canadian political philosopher, author of a book called A Secular Age. And in their report, they spent, in my view, fatally, a lot of time trying to define what secularism meant. Right? Open secularism, closed secularism. And they invited a white paper from the government. They said Quebec should open up a white paper and produce legislation that would help with religious accommodation, that would help to define its approach in relationship to religion. Well, the Parti Québécois took up that offering, right? And they took it up and did a number of things with this legislation that we're talking about, the Charter of Quebec Values. They did a number of things. It wasn't just about one thing. They made amendments to the existing human rights instruments that would emphasize equality rights. They gave a broad scheme for handling accommodation claims. But an important amendment was the addition of this new statement of purpose in the preamble to Quebec's Charter of Human Rights and Freedoms, another charter. It said, whereas equality between men and women and the primacy of the French language, as well as the separation of religions and state and the religious neutrality and secular nature of the state are fundamental values of the Quebec nation. And then it went on. It affirmed this notion, equality, very importantly, separation, and the secular nature of the state is what impelled what was to come. You can see from this, the new bill was very much framed as an appeal to something called the secular nature of the state. Right? It was all a statement of belief in secularism. And everything that was about to come were framed as natural products of the demands of secularism. Secularism means these things must be law. And indeed, the claim was even more particular, right? It wasn't just the secular nature of the state. Right? In French, it was the caractère laïque de l'État, the laic nature of the state. And in that, they were appealing to a French concept of secularism, one of many concepts of secularism, called laïcité. And they said, laïcité, like in France, where the main identity is that you are a child of the Republic, everything else should be pushed to the side, that's more natural to the French culture in Quebec. Right? This is part of an appeal to a French sort of genetic history that was being made with this language. Now, the bill did more, requiring, very importantly, anyone accessing public services to not have their face covered. That's just purely a reference to the niqab, to the face covering. But the real flashpoint in the proposal was the government's imposition of a restriction on wearing religious symbols. Employees of public bodies would be prohibited from wearing headgear, from wearing clothing, jewelry, other adornments that would indicate religious affiliation or religious identity. Now, when you think about this, public bodies, those in public bodies, would not be able to wear these things. Public bodies is a very broad concept. Municipal authorities, transit boards, school boards, colleges, universities, hospitals, health services. And so after a period of transition, it would mean that anyone remunerated by the state, by the Quebec government, or otherwise discharging a public service, judges, tribunal members, right, police, prison guards, could not wear any identifying conspicuous religious symbols. So the heart of the debate was this graphic. Right? So the state, Quebec government, put together this cartoon, right? This infographic. It would say, you could wear these things, right? And the first one is a half moon with a star, right? These Islamic, and I've had people tell me like, I've never seen them, but they're lovely. Like, where do I get them, right? Okay. And then some things like this woman with a spread collar and a huge pectoral cross, right? Not allowed. So two things reflected. Things that you could, right? Examples of signs that are non-ostentatious religious symbols that were permitted, subtle things, right? The ever-present Star of David ring, right? And then signs that were ostentatious. Kippah, right? The niqab, the hijab, turban, pectoral cross. You can see this was a debate about religious symbols, about the state defining the meaning and significance of religious symbols. And this kind of definition of what was permitted, what wasn't, seemed more familiar to a place like France, where this debate took place, or to Turkey, where this has a totally different valence. But it was here in Canada. And it sparked enormous debate, enormous excitement, and really, admiring Quebec culture as it is, was reacted to with this wonderful Quebecois sense of criticism and humor, right, by many. And so this was put up by one person who was running for office, Jess Salmon, who said, really, I'll do an infographic, like things that make me uncomfortable versus things I like to see, right? Like that's really what you're talking about, right? So the Leafs make me uncomfortable, but you can wear, right? So humorous, but critical, right? Humorous, but critical. There were substantial portions of the population in Quebec who endorsed this approach, endorsed the government approach. There were also substantial portions of the population outside of Quebec, around 40% of the Canadian population, right, that endorsed this approach. But within Quebec, minorities and Anglophones overwhelmingly concentrated in Montreal, as well as professionals, universities, objected fiercely. And voices from outside Quebec, not realizing actually how much purchase this had outside Quebec, right, cast it as multiculturalism in Canada, laïcité in Quebec. And there was a lot of criticism of the culture and purported xenophobia in Quebec. And indeed, from inside Quebec, there were highly critical political cartoons, right, about what was going on, right? Really critical. Really critical, right? Now, importantly, the reaction was also that this proposal was clearly unconstitutional, judged by the Canadian Charter of Rights and Freedoms. And I'll tell you this, right? It was almost obviously true. Right? Clearly unconstitutional based on the constitutional law defined through the Canadian Charter of Rights and Freedoms. Right? And I'll come back to that point. Of course, in the winter, right, the Parti Québécois, boosted by a sense of polls and appeals to this notion, wanted to put the fate of this bill at the heart of a snap election. They called the election, and they were routed. Right? They were routed probably for economic and sovereignty reasons, right? And the bill sort of receded as a product as well. So it's on the back burner now. We don't know what will happen with it. So what I want to do with the rest of my talk is to tell two different stories that try to make sense of this piece of legislation and this remarkable political moment in North American law and religion. So story one way we could read what happened with this Quebec Charter. The first story would be a story of discontinuity and change. This story would begin with a recognition that the defining character of Quebec in the 18th century were the origins of the country, and Quebec specifically, devout Catholicism. Origins of the country, Quebec, distinctively, deeply Catholic. Quebec society was deeply Catholic in a Protestant Anglophone sea. And it's indeed interesting to note that the Ultramontane movement, a highly ultra-papal version of Catholicism that said the state is subordinate to the interests of the Pope and of the state, it had a lot of roots in Quebec late into the 19th century, right? A very strong form of Catholicism. And yet, this story would go, that's the origin. But if you go to the polls now, Quebec and Quebecers are among the least willing to identify as religious, are highly skeptical of religious authority, and have some of the most progressive views on issues like contraception, same-sex marriage, that are in tension with Catholic life. And this radical transformation, this story would emphasize, took place, of course, in the 1960s. With the Quiet Revolution, in which Quebec society pushed back on Catholicism and institutions of Catholic dominance and tried to untether the Catholic Church from political authority. This was a hard break, a radical transformation of life in Quebec. It touched on education, it touched on politics, it touched on everyday social practices. And so read in this story about a highly religious society becoming non or even anti-religious over time, the secular charter was just a kind of speed bump or trouble spot in a progressive secularization of Quebec society. On this story, story one, Quebec is a kind of paragon of secularization. It's just moving strongly down this view. The nature of the Quebec Charter, sure, debatable. Some will like it, some won't like it. We might challenge it, we might accept some, not other bits. But those particularities can be explained by this hard break with the church, by sensitivity around Francophone culture and Quebec identity. But this contested moment on this reading is about contesting versions of what secularism might look like. So on this quick read, the legislation is about working out a vision of the secular and what it demands. Right? Discontinuity. Highly Catholic society moving to highly secular, and this is a speed bump along the way to that process of secularization. That's story one. That's how you could understand what's going on. I think it's appealing in some way. And yet, it turns out that the concept of the secular is actually doing mischief to our understanding of what was going on here. It's running interference, in my view, on what's really going on at that moment. To exploit just a crack in the wall, this appeal to laïcité as being the natural concept of secularism in Quebec is radically anachronistic. Right? The idea of laïcité as a way of organizing religion and state in France settled in 1905, the start of the Third Republic. Right? Quebec was highly Catholic before that and well into the 1960s. There's nothing natural about laïcité to Quebec society, quite the contrary. But it suggests that the appeal, right, to laïcité, even if it's not historically accurate, right, had something to commend it to the politicians that wanted to make that call. And so now let me give you story number 2. Story number 1 was about a society in which you could see radical change, discontinuity, along an arc of secularism. Let's try another story on for size. This story looks to the origins of the Canadian state. And it sees that the Treaty of Paris, 1763, which I've put up here, not crucial, I just wanted you to see some text of it. This treaty, which is our first constitutional document in some readings, settled the claim between French, English, and Spanish crowns in North America. And it included only one concession for the French. So what you see is the French give up this and this and this. I mean, they lost. They give it this and this and this, right? And then His Britannic Majesty will concede one thing. And this is a quotation from within this element. Let me see if I can find it here. Yes, His Britannic Majesty here. His Britannic Majesty on his side, right, agrees to grant the liberty of the Catholic religion to the inhabitants of Canada. He will, in consequence, give the most precise and most effectual orders that his new Roman Catholic subjects may profess the worship of their religion according to the rites of the Romish Church, as far as the laws of Great Britain permit. One concession: Catholicism. In the Quebec Act of 1774, again, an essential document in the founding of Quebec as a province, we found again a declaration that His Majesty's subjects professing the religion of the Church of Rome of and in the said province of Quebec may have, hold, and enjoy the free exercise of the religion of the Church of Rome, subject to the King's supremacy. And then later, in the British North America Act, our constitutional document, our first act of confederation, the Supreme Court of Canada recognized in the 80s, in the 90s, that the key provision for confederation, right, the sine qua non, the piece on which confederation lay, right, the contemporary Supreme Court has said, was the allowance for Catholic schooling, right, outside of Quebec and Protestant schooling within, a recognition of a distinctive relationship with religion. And so, the political identity of Quebec has always been fashioned through claims about a special relationship with religion. Now, this story about Quebec and about the Quebec Charter in particular also looks to more modern constitutional and political history. It recognizes that the Quiet Revolution in the 1960s was joined with a growing sovereignty movement, one in which a reconfiguration of the relationship with the Church was associated with a reconfiguration of Quebec's place in Canada, the rise of the Parti Québécois. And this story also puts the so-called Charter of Secularism as part of a narrative that includes the fact that when the Canadian Constitution was patriated in 1982, when it brought the Canadian Constitution into domestic political control, a constitution that would include the Charter of Rights and Freedoms, Quebec never signed it. That failure to sign on in 1982, which is a fact of our political lives right now, it's never been agreed to by Quebec, led to the referenda on separation in Canada, the famous Supreme Court of Canada secession reference that set the terms for what would happen for the secession of Quebec from Canada, and that's really salient right now with what we've seen in Scotland. The Parti Québécois have been working since those 1960s as a sovereigntist party, a dominant force moving towards some form of sovereignty for Quebec. Now, I'm giving you a lot of facts here, but what does the Charter of Quebec Values look like here in this second story? Well, let's lay it out in this way. The Parti Québécois has struggled in recent years in its sovereignty platform, in no small measure because Canada has fared so well economically, buffered from some of the major ups and downs in other parts of the world. So it has struggled on the sovereignty point. Let's turn to the observation I made earlier, true I think, that this Quebec Charter is manifestly unconstitutional according to the Canadian Charter of Rights and Freedoms. So then why introduce this bill? The introduction of the proposal for the Charter of Values excited passions about religion, about difference, about how Quebec might do things differently than the rest of Canada. The claim was that this approach was a distinctively Quebec way of doing religion and state. Quebec's pursuit of secularism introduced a kind of Quebec rest of Canada divide, right? At least at the political rhetorical level. And so let's play out what it would have looked like if the Parti Québécois had passed this piece of legislation and it had been challenged through the courts. What would have happened, everyone? A bill called the Quebec Charter of Values. Remember I said the name mattered. Quebec Charter of Values, manifestly, specifically named that, would go up to the Supreme Court of Canada, and this federal institution, sitting in Ottawa, would rule Quebec values unconstitutional according to a document that Quebec had never agreed to. This is a sovereignty dream, right? A scenario for the invigoration of a sovereignty movement that was struggling. At a time when there was a lack of appetite on questions of sovereignty, the invocation of secularism, of that language, served potentially particular political purposes in exciting a debate. It promised a boost in the polls, which led to that snap election. And if the bill passed, and if it were challenged, it would bring in a substantial lever talking about differences between Quebec and the rest of Canada, talking about the justice of a constitution that didn't include one of the founding peoples of the country. And so notice now, if we pull back to the secularism point, this story is one about continuity. It's not about change. It's about religion in Quebec always being a basis for distinction, for differentiation, a distinct relationship with religion since the period of the Treaty of Paris up to the Quebec Charter, always being one means in which the project of Quebec political sovereignty has been worked out. This is not about the concept of the secular or about the demands of the secular in any universal or ideal sense. It is about secularism, but really only as one available marker for a debate about distinctiveness and about how politics and a relationship with religion, right, help to mark out what's distinct about a society. So let me then close off this piece of North American constitutional history with a return to the point that I was querying early on. The point about how useful is it for us to organize our thinking about law and religion around a study of the nature of secularism or of the demands of the secular. You'll recall that I said that there are some things that can be gained from this kind of reflection about broad currents and big concepts. That these interesting things are worth thinking about, but they're thin and light, right? They travel far, but maybe they don't tell us that much. Well, that interesting thin and light idea that helps us in this context is that there's something about appeal to a special relationship with religion that remains important in Canadian constitutional life. Maybe it's genetic in our approach to defining political community, in part on the nature of the relationship with religion, and about sovereignty being worked out in part through trying to work out your relationship with religious communities and religious authority. On this view, this thin and light idea is that secular is one important rhetorical resource that can be grabbed onto to engage in a project of seeking political distinctiveness and sovereignty. It's, of course, only one of the things you can grab onto, only one of the ways in which relationships of political authority get defined. But it is a relationship that we see as key around the world. Right? The relationship between political sovereignty and a relationship with religion is very important to Israel's identity, to India's identity, to England's identity, right? To Italy's identity, to Turkey as a politically sovereign country, all in different ways. In the US, I too hear that language about religion as being about trying to find distinctiveness about their project of political sovereignty. But the most interesting lesson to me in this quick story is that the close examination of the happenings in law and religion in Quebec tells us really and points to how little of interest general reflection on the nature of the demands of secularism can actually show us. How little of interest it can tell us about what's really at stake. How little it points to the particular political motives and the local histories that go into filling the content of these big concepts. And indeed, taking the level of rhetoric, taking the concept of the secular too seriously, actually hides some of the most revealing contours about what's happening in the relationship between law and religion. And so I'll leave it at that. Thank you. I look forward to questions.